Good morning, good afternoon, and good evening. So today we are going to be going over how you should be dealing with a district attorney if you decide to get on the bench. I like to get on the bench because I have fun with them, but everybody's different. But if you do, I would recommend you do it exactly like this. This is how I do it, and it works. It succeeds. Because it's not saying no and it's not answering, but it's not saying no, I'm not going to answer. So this is how you would deal with a federal or any type of prosecutor regarding any type of prosecution. If you can understand, Mr. Prosecutor, it appears you are assuming facts, and that is not in evidence. And because you have not given me the evidence, you have not given me enough knowledge or information to form a responsive answer. Again, Mr. Prosecutor, it appears you are assuming facts that are not in evidence. And because you have not given me evidence, you have not given me enough knowledge or information to form a responsive answer. Now, this is how you should answer. Is you're avoiding answering them in a way that they can't put you in jail for contempt because you did not with that kind of answer you did not refuse to answer. You were arrogant. You weren't arrogant, you were just straightforward. You give them just enough information and knowledge, but they never reveal it. Why? Because they don't have it, or they don't want you to know it. And I thought we had the right to be fully informed. So when you deal with a prosecutor, all you're going to say is, Mr. Prosecutor, it appears that you are assuming facts that are not in evidence, and because you have not given me the evidence, you have not given me enough knowledge or information to form a responsive answer. And this is something you want to memorize, because when you do that, it really does piss off the prosecutor, because you answered, but you didn't answer. And it's a way to make an answer to actually challenge the prosecutor's evidence as well, because he hasn't performed any evidence. I've seen it in several preliminaries that have occurred. No evidence was put in. So these are things you can do to counteract some of the district attorneys or federal prosecutors or whoever's trying to prosecute you acts. Well, you haven't provided me with no evidence, Your Honor. There's no evidence in this case. There's no competent witness to this matter. Remember, competent witness, competent evidence, affidavit, oath, saying that they swear that this is true and everything is true and correct to the best of their knowledge, blah, 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 that whole thing. But yeah, that's how you would deal with a prosecutor if you were to stand trial, and that's how you would actually answer the prosecutor for every answer he gives you, no matter what the answer is. Mr. Prosecutor, it appears you're assuming facts that are not in evidence. And because you have not given me... See, I gotta study this again. Mr. Prosecutor, it appears you are assuming facts that are not in evidence, and because you have not given me the evidence, you have not given me enough knowledge or information to form a responsive answer. See, that's what you want to memorize. You also want to remember that you are not just the prosecutor. You're not just the... this is only if you choose to take the stand and testify, if it even gets that far. With the remedies that I've given you under 2 U.S.C. 2, 3, and 9, and the exclusive remedy that I'm going to further give you to resolve any legal matters, please be advised that it will dramatically change anything and everything that you do with legal matters. Once you learn this stuff, you'll never be the same. legal matters will be changed. Now, it's picking and choosing. Like, you go into a 99-cent store, you're not going to say, well, you need to sign this contract. No, don't work that way. No, you don't want to do stuff like that. You just go in there with a small amount of cash. You always want to carry still the dollar dinero, the dollar debt dollar on hand. It still has value, but ultimately we want gold and silver is what we want. And that's the real currency. That's the real currency that should be ran through the government, but it's not because the government's de facto. But remember, that's the information that you need to know how to go about talking to the prosecutor when you're on the stand. They usually say don't talk to the prosecutor. I say, why not? You already put me in fucking jail, so that's another way to learn. There's Mr. Prosecutor. Mr. Prosecutor, it appears you're assuming facts that are not in evidence, and because you have not given the evidence, you have not given the knowledge or information to form a responsive answer. This should also be your opening statement. But it should be, Your Honor, Your Honor, it appears that it should be Your Honor, Mr. Prosecutor. The prosecutor it appears that the prosecutor is assuming facts that are not in evidence, and because they have not given me the evidence and have not given me enough knowledge or information to form a responsive answer. See, that will then stud them as well. Well, I can't form a responsive answer because I have no evidence. Remember, discovery starts as early as arraignment. That's very important for people to understand, that they just make you enter into a plea. Well, I haven't seen nothing that proves that you're saying what I'm saying, is that you're saying what is going on. There's no evidence there. So, I recommend, again, putting this into a type of legal. It doesn't even have, it just has to be it could be just that. Boom, Your Honor, blah, 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 on date 6/26/2006. I was involved in a police brutality. I was involved in an incident on ABC Street at 123 Main Street in California, right? And Your Honor, on this date, I hereby request that the court consider a dismissal, because, again, the judge, you have to state that they're presuming evidence. They haven't provided you. Remember, they haven't provided you with nothing. This is really how you go about dealing with them as well. Remember, discovery is everything. It's not just, I'm a secured party creditor. It's, I'm a secured party creditor. Where's the evidence to show that any injury has occurred? Remember, you're a company that's liable. Remember, it's not just when you have a company, it's not just having the company. I have the company. No, you're still going to be held liable for insurance. You just got to make sure that if anybody gets injured, you have insurance for that. You have coverage for your workers. You have insurance waivers. You have a whole bunch. It's a whole bunch of stuff. Easier than it looks, and I'm gonna go step by step with everything. So, excuse me, I got something in my throat, and that's what she said. The reference I was making was the 80th Congress session, session 645, June 5th, 1948. That is an important date that talks about security instruments. That's the one that talks about the birth certificates it mentions. But that includes birth certificates, which are financial interest because 1933, and the governor's pledging our stuff over as security bonds, our birth certificates over security bonds. So we became straw men. Boom, right there. Black and white. People, it's so easy. Even a child could do this. You gotta see through the logic of these vermins. Please remember to click that subscribe button, that like button, if you like this. If you don't like it, well, too bad. First Amendment. Second, your opinion does matter. Negative opinions do matter too. But please remember to have polite conversations. Be polite. Be nice. What did Patrick Swayze says? When they're nasty with you, be nice. Or when they are nasty with you, be nice. And you'll know when to be nice. But yeah, no. These people are using legalese to confuse our people, and the people need to realize that sovereignty is secured party creditor. Sovereignty is secured party crediting. And I'm still waiting on my papers back from the Secretary of State. It can take up to a couple of months. I did mine online. I just can't print it out right now. I am also trying to get a certified copy, so that's why I'm asking, because I want to show a certified copy. I want to just not just show an original, but I want to show an original with a certified copy, so you can see this is an original and this is a certified copy. I also recommend people register their business, even if it's an out-of-state business. Register it with Contra Costa County. Do not register it in your name. Register it in all capital letters. Remember, that's the man who owns it, the company, the estate. And now you have a company backing your business. Now you have the estate, the business. You can make an LLC, you can make it a corporation. I have a corporation and an LLC. Well, technically I don't own the corporation, but I do have an interest in the corporation, and I am the owner of the corporation. Not owner, but stockholder is what I meant. I'm a stockholder in that company, so I hold stock, but I don't own that company. That company is owned by another estate called John Adam LLC, and that company is, I believe, it said out of Minnesota. It said from Minnesota, which is the corporation, which is the government, which is owned by Adam, which is an LLC. But I own neither. I own only stocks in those. I only own financial stock interest in those. So I do have security interest in those matters. But you see, it's a layer of security that's used. Secure party interests are very, very, very important. I'm going to copy a video and download it to this page so others can see it. Again, click that like, subscribe button, comment please. I want to know what you have to say. I'm going to also put definitions of things like judges, administrators, what their duties and jobs are, what a trustee is. I've put those in debt videos, so please see those debtor videos too as well. There's a lot of information on those. I've seen a few comments. One guy called me retarded. I have a little bit of a speech impediment because I like to piss off the corporations, and police like to kick me in the head. So if you have something that you would like to say to me, you can come and see me whenever. I'm in California. I'm everywhere. I'll come and visit you, and we can have a intellectual conversation to see really who is retarded. Because if I'm retarded and you're clicking on my page, then who's the really retarded one? But I digress. These individuals will continue these until you contact the Secretary of State and tell them, hey, I'm a secured party interest. Hey, here's a Form 56. hey, here's my 2488 form for attorney of record. I am the attorney of record for the estate. See, that changes the whole criteria of what you're saying, what you're doing. Remember, you're the beneficiary equitable title holder, so that's important. But again, please, this video is, remember, this video is good information. All the information here is information that I've acquired from other sites. And that all this information is from government agencies or laws that they have passed. This is all good information. If you have any legal information that you'd like to send to me, I'll send a link below. If you have any legal questions too, feel free to answer those. I'm giving my business email so people can contact me there. Please note that any communication does not automatically extend to a contract or any type of agreement. That would be a forced contract. That would be a silent contract, and I don't do silent contracts with people. I will let you know in writing. Please wait. It may take up to a couple of days to respond sometimes, but I'll get back to you as soon as possible regarding the matter. I do understand time and statute limitations. I do understand this. If you have legal questions, feel free to ask and send down to that email. It's 12W ORLD UNITED PRESS23. So it's 12 in the front and 23 in the back. And then it's at at protonmail.ch. And I'll put that in the bottom. If anybody has questions, again, feel free to ask. I'll feel more than gladly answer your ask your answers. I do research. I do also charge small fee, $50, because money doesn't really have value. But I do charge a small fee for people who wish to learn further, meaning that if you wish to spend $50, or it's like $55, I believe, depending on the state you're in, I'll more than gladly give you the information to your state so you can find that information for your UCC. I'm not taking I'm not taking any money. I'm not spending any money. I'm telling you, this is where you, like in the state of California, I believe it's like 50. In Minnesota, it's $55. $55 in the state of Minnesota, and I have a UCC, LLC, corporation, S corporation, C corporation. I can set up a business, literally, for that amount of money. And I'm going to show you how. All you have to do is email me. So, if you are interested, please. That concludes today's video. Enjoy. Remember that true citizens who are sovereign do not have to go about saying, hey, I'm a sovereign. If you know you're sovereign, you have the paperwork, you have everything secured the way it should be secured, I think you should be fine. You should not have to worry about anything. No stress on bills, nothing. There is ways to pay bills. I will get into that at a later date. Please Again, thank you. Have a safe travels wherever you may be going. Remember that only through knowledge can we break through the deceit. Thank you. And again, have a wonderful day.